Hey, Zach.
So wait, before you start.
The subcommittee will come to order. When we left, we were debating, or we were finishing the debate on the manager's amendment, but I mentioned that we would continue that if any member wanted to comment on the manager's amendment or ask questions when we returned. And then after that, we'll start with our amendments to the manager's amendment. So do we have any members that would like to make a statement on the manager's amendment?
Mr. Chairman.
Mr. Shimkus?
It doesn't look like the ranking member will be here. He'd asked me to follow up with one last section of questions to council, if I may. On page 17, line 21 of the manager's amendment through 26, it states that the World Trade Center program administrator shall enter into partnerships with local governments and organizations with experience performing outreach to affected populations, including community and labor organizations. The question is, how much is authorized for these functions?
If the council would like to respond.
I just need to check one thing, sir. Yeah. It's the same one. Yeah. So, Mr. Shimkus, on page 90 of the bill, there is a separate authorization for purposes of carrying out separate section 3103, and the amount specified there is for fiscal year 2011. Sums as may be necessary not to exceed $2 million. And then for each subsequent fiscal year, that amount would be increased by the Consumer Price Index.
Follow up then, does that, the partnership mean they can enter into contracts with community and labor organizations to conduct the outreach?
I'm sorry, sir.
This $2 million, are they allowed then to contract with people to do outreach?
Yes, sir. That's what it authorizes.
And so organizations like ACORN could then qualify for use of these funds for outreach?
It doesn't specify a specific organization other than local governments and organizations with experience performing outreach.
So I would assume the answer is then yes. I mean, that's one of the major roles of ACORN is to do community outreach. I would assume that would be correct then. Let me just, following up on this line of questioning, the Centers of Excellence to perform outreach. We have Centers of Excellence already that are defined to do this very thing, do we not?
There are existing Centers of Excellence.
And part of their mission is to do this outreach?
It may be part of their responsibility under the current contract. I'm not familiar with the terms of the contracts.
Would the centers be paid for this outreach?
The Centers of Excellence under their current contracts would be reimbursed for carrying out their activities and responsibilities under the terms of the contract.
Yeah, and I guess the final point is I think
I'm
what
sorry,
we have...
I just don't know the terms of the contract.
Yeah, our research shows that then you're going to have two groups doing the same thing, which is outreach, and we'll be paying them to do the same thing, and this just more things digging into the bill that we're trying to identify that we could probably clean up in this process if that duplication is not really required if we want to be somewhat fiscally conscious in this bill. Mr. Chairman, that's all I have. I want to thank counsel for those answers.
If any other members have questions, gentlewoman from California, Ms. Eshoo.
Thank you, Mr. Chairman.
Recognized.
On page 17, line 25, including community and labor-based organizations, would the League of Women Voters be part of this too? I mean, I know that my Republican friends love to talk about and spook people about ACORN, and I think that it's like throwing a mud ball at the bill. There are, we know, countless organizations that work in communities that do extraordinary work. So I think that we need to make clear here that there are many of them. Would the League of Women Voters be, would they qualify to be a community organization that could be a partner with local government in performing outreach to the community?
Again, the legislation doesn't specify a particular organization. The administrator would make a judgment if the organization had experience in performing outreach to affected populations, and any organization that meets that criteria in the administrator's judgment would qualify.
Good. Thank you.
All right. Any other comments on the manager's amendment? Otherwise, we're going to move to amendments to the manager's amendment. Does any member seek recognition to offer an amendment to the manager's amendment? Mr. Burgess is recognized.
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment, and the amendment will be distributed if it hasn't already. I didn't see Mr. Rangel is here. Thank you for being with us. Yes, the clerk.
Amendment to the amendment in the nature of a substitute to H.R. 847 offered by Mr. Burgess. Page 81, after line 16, insert the following.
The amendment has been distributed, I take it, or is being distributed. And without objection, the amendment will be considered as read, and I would recognize Mr. Burgess for 5 minutes to explain the amendment.
I thank the Chairman for the recognition. This amendment seeks to limit the attorney's fees that would be provided under the potential settlement agreement reached between the City of New York and several first responders last week. Under the agreement, the limit on the fees would be based on New York's existing medical malpractice laws. This amendment is a fiscally responsible way to give injured people access to settlement money without forcing the United States government to pay for excessive attorney fees or to pay for costs that are the responsibility of others. The amendment states that if any of those funds paid by New York City under the settlement are counted towards the cost share of the New York City $510 million as required in the bill, then attorney's fees can be no more than 23% of the total settlement. The city reached a potential settlement deal of personal injury lawsuits filed by 10,000 first responders last week. Plaintiffs have 90 days to agree to the terms of the settlement agreement. Plaintiffs sued based on claims of developing health problems after working in the ruins of the World Trade Center. The settlement would compensate the responders based on the level of injury. The total settlement is up to $657 million, and attorneys' fees would be around $200 million, or 30%. This amendment seeks to cap the attorneys' fees in a similar manner that New York currently caps medical liability lawsuits. In New York, under medical liability lawsuits, attorney fees are limited and based on a sliding scale. The claimants in this case have serious health injuries. Allowing attorneys to take a third of the money limits the availability of funds to those truly in need. If limiting attorney fees is good enough in medical liability cases, where the plaintiff has also been injured in a similar way, why is it not good enough for first responders? So again, if New York City wants to meet its obligation under the bill, then attorney's fees will be capped at 23%. There is no effect if the city did not try to use their payment in claims toward their mandatory contribution. Think of this as a fail-safe mechanism to protect patients and ensure those dollars that go towards compensating those injuries actually do go to people and not to plaintiffs' lawyers. So again, it is a fail-safe mechanism. If if it is under a litigation action, then the cap applies. No effect if the city is not trying to use their payment in claims toward their mandatory contribution. And thank you, Mr. Chairman, and I see the time, but I will yield to anyone else on my side.
The gentleman yield to me.
I'll be happy to yield.
I don't know. I guess I'm getting in my own 5 minutes here, but whatever. Okay. I'm opposed to the amendment because, frankly, I just don't see how it's relevant. I'm not talking about germaneness. It's germane, but I just don't think it is relevant, and I just don't want to put things in the bill that don't seem to have any impact, positive or negative. Last week, when this settlement or proposed settlement between New York City and a number of plaintiffs was announced, it really had nothing to do with health care. Any payments made under that settlement, first of all, are paid out of the federally funded captive insurance fund, so they're not New York's money. But beyond that, it's not health care related. So even if this settlement goes into place, New York City would still be required to pay 10% of the cost of the program, or the $510 million. And the only way that New York City's obligation under the bill can be fulfilled is by paying for treatment for World Trade Center-related health conditions. No attorney's fees can be counted against their obligations. So I just think I'm not trying to, be disparaging in any way, but attorney's fees can't count. Federal funds can't count. Anything not related to treatment can't count. So I just don't see the point. And, of course, you could tell me, well, if there's no harm, put it in anyway. But I still think that we shouldn't be, cluttering up the bill with things that I don't think are meaningful. So that's why I would oppose it, and I would urge my colleagues to vote against it.
Would the gentleman yield just briefly on that point?
It's missed. Oh, I guess it's my time, yes.
And I won't take my own time. I just think it's important. This is a good moment for us to make this point. What you've been reading about in the newspaper, those settlements that have been offered and have not yet been accepted, are torts, separate and apart from the health costs. Even if 100% of those people accepted 100% of the offer, it does nothing to protect the overwhelming number of people for their recurring health costs, the result of being at September 11th. So it's a whole different package of things going on. And while I understand the gentleman's very consistent position on this issue, I think it's important to note that you may read in the newspaper, oh, there's been these claims offered, this agreement offered, why do we have to do anything? This is a point that Mr. Pallone makes here, that this is a completely separate thing that they're trying to solve with those claims, and it touches a relative fraction of the people that this bill does. And I just want to make that clear. They're not health-related claims, they're tort claims.
Is you want me to, I'll yield to you.
Yeah,
sure.
if I could just, again, in that instance, then the bill does no harm, but it does provide protection, provides protection to the people who were injured and keeps those dollars going where we want them, to the people, not to the plaintiff's bar. If there's no effort on the part of the City of New York to use their payment in claims toward their mandatory contribution, then this amendment has no effect. But in the future, if there is that attempt, this would limit the amount of those dollars that could be spent on attorney's fees and would limit those attorney's fees so that 23%, the 30% is not diverted from the patient's care, only 23% is, which still seems generous to me. Seems extremely generous. But why would we not be in favor of putting the money toward the injured party?
Would the gentleman yield on that?
Well, let me reclaim my time, and then I'll yield to you. I understand what you're saying, but my concern is that when you put in language like this, it may give the impression that somehow we are allowing non-health related payments to count. And I think it's pretty clear that we're not. So, if you put this in, who knows, some court may look at it later and say, oh, that means that, they were somehow trying to count things that are not health-related. I think the language is pretty clear, and if anything, it just causes more confusion. Mr. Wiener would...
Well, I think the point is, I just would caution my good friend that you're setting up a little bit of a straw man here. You're not really accomplishing what you think or you may want to in terms of dealing with these cases that are outstanding. There may be some legislative way for us to go and do that, but it certainly isn't in the context of this bill. Now, you say, well, what if a different bill came along that change the definitions, and then you may need that protection. Well, I think it's a strange. I don't think we should pollute the bill with that second-tier hypothetical. And let me just say something. If you're concerned about this issue, and there you can argue both sides of it, I can tell you the City of New York has fought tooth and nail with the largest law firm in America, which is Corporation Counsel, to stop there from being these lawsuits from being successful. They've been resolved after 8 years, and I don't even know if it's going to be settled. And I don't think you want to send a message that the people representing the victims shouldn't be able to hire whomever they want. And also, I would say that if you're concerned about this, a judge still has to approve this settlement, and they can too say we think 23 is too high, and this is the source of some controversy back in New York. But I just want to tell you that if you think that this is somehow protecting taxpayer money or somehow limiting New York's options because of this language, it simply doesn't do that, because none of it is eligible for the offset of the 10%, and none of them are health-related claims that are currently pending before the courts.
Let me recognize Mr. Engel on his own time for 5 minutes.
Yeah, thank you, Mr. Chairman. There's also something else happening here that I really wish wouldn't happen. You know, we have a lot of quarrels between the parties on a lot of different issues, and I know that my friends on the other side of the aisle, you know, like to mention trial lawyers as a Democratic constituency, and somehow trial lawyers are always supposedly going to benefit with things that the Democrats do. I know Acorn was mentioned before, and, you know, all these kind of bugaboos, all these kind of straw men or red flags are being raised on the other side of the aisle, and I would just say, please don't. This is nothing. This is separate and apart from Acorn, separate and apart from trial lawyers, you know, separate and apart from all the things that we could have disagreements with on, you know, a number of issues ad nauseum. But what we're really talking about here are the people who came as first responders who are now sick. Selfless people who are not looking to rip off the system, but only need to be compensated for dying or for being so much in bad health that they need the government to help. And I just hope that in the rest of this afternoon, when we're marking up this bill, we don't start raising all these red flag issues, because it really doesn't belong in this discussion.
Would the gentleman yield?
Yes, certainly.
We offered numerous times in good faith to work at a bill that we could pass on a bipartisan vote, probably 100%. And I've talked to a lot of the New York delegation, and I mentioned it in my opening statement. So that was rejected. Okay, and I think it would be helpful if we want to move this bill to the floor, and you want to get the bill moved to the Senate and get a bill passed and signed into law. So, you know, just because we're concerned about a law firm getting $200 million, or if we're concerned about tax dollars going to community organizations that break federal law, if that is so egregious in this debate, then I'm sorry. But we can address things legislatively to make some of these corrections. And until we're invited into the room, this is our only forum.
Well, let me just say, reclaiming my time, I think that, you know, no one is going to make excuses for an organization that breaks the law, whether it's Acorn or any other organization, but that's not really what we're talking about here. The disagreement, the fundamental disagreement that we seem to have here is whether this should be mandatory versus discretionary. Now we believe very, very strongly that it needs to be mandatory and not discretionary. I know that based on what people have said on the other side, you believe that it should be discretionary. Well, it's very hard to compromise that, because the question is, you know, is it mandatory or is it discretionary? So I think that if we can agree that this ought to be mandatory, there's a lot that we could compromise on. But we cannot compromise on whether or not it should be mandatory or discretionary, because we feel it needs to be mandatory. And I had some discussion earlier before with the gentleman from Indiana, and who raised the issue of veterans not being mandatory. And I said, well, I'd be willing to vote to make it mandatory. We shouldn't be pitting veterans against the 9/11 responders, just the way we shouldn't be pitting trial lawyers or any of the other red button issues. That's what I'm saying. So I would hope that when push comes to shove and this bill is ready to be signed by the President, that we could have a mandatory entitlement. And I'm sure a lot of the things that you want to try to do on the other side of the aisle, we're willing to listen to and compromise. But we're not willing to compromise on mandatory versus discretionary because we feel the serious nature of what happened on 9/11 and how people responded, and that the country really has an obligation to these people because, you know, we were attacked. We were attacked because we were in New York City, but more importantly, we were attacked because the World Trade Center is was a symbol of the United States.
Gentlemen, does the gentleman from New York want to yield to Mr. Burgess?
Certainly.
Yeah, just if I could. We've gotten a little bit far afield. I don't recall talking about Acorn. I think I was very careful not to use the term trial lawyer. I referred to the plaintiff's bar. This is about protecting people, and that is what we should be about with this bill. Yes, this bill has been a long time in its genesis. 9/11 happened before I even came to Congress. 9/11 was one of the reasons I ran for Congress. This bill is important to me. I am one of your 2 co-sponsors that I'm aware of on our side of the dais. I am mystified as to why we were not included more in the discussion as the manager's amendment was drafted. If there are shortcomings of this amendment, bear in mind we only got the manager's amendment less than 24 hours ago and had a very short period of time to develop. But this seems to me to be the most basic of patient protections, the most basic of protections for individuals, the most basic triumph of the individual over the big guys. We want to protect people's rights to receive compensation for those injuries. And if in future lawsuits, future health-related lawsuits, certainly the point remains. We don't want those payments in future health lawsuits to be used by the city to meet their obligations. We certainly don't want more money to go to the plaintiff's bar than to the injured parties. And I know we spent more time on this than you intended, Mr. Chairman. I'll yield back to the balance of my time. I'll yield back to the gentleman.
Mr. Engel's time has expired. Does anyone else want to be heard on Mr. Burgess's amendment? Okay.
Mr. Chairman.
Who seeks to be heard?
Sounds like a joke.
Oh. Mr. Braley, did you?
Yeah, I just think I want to respond to
the gentleman is recognized.
I want to respond to Mr. Burgess's argument because it's the most important reason to vote against this amendment is the doctrine of federalism. He made reference to the fact that New York had placed a cap on attorney fees in medical malpractice cases. First, this is not a medical malpractice claim we're talking about in these tort claims in the state of New York. Second, the decision to cap those fees was made by the New York legislature, not by Congress. And I'm sure that if Congress tried to pass a restriction or a cap on attorney fees, raising the attorney fee on tort claims in the state of Texas, it would be greeted with great disappointment, and that's why this amendment should be defeated. If anybody's going to place a restriction on attorney fees, it should be left to the people of New York. They're the ones that are most directly affected by this, and that's why this amendment should be defeated.
I move to strike the last word.
Yes, the gentleman from Indiana.
It is a curious thing for someone to cite the doctrine of federalism who voted for the Obama health bill. That is a curious thing. So that is truly picking and choosing when you want to use federalism as an argument or not as an argument. The other thing, I was a good listener to my good friend, Mr. Engel, and I think he is absolutely right. This boils down to a division on policy, Elliot, with regard to mandatory versus discretionary. And we don't want to pit the 9/11 responders against those who are serving in the United States military today and those of whom are in the past. But the choice that you're making by putting this bill in consideration today is that you are pitting them against our military. And that's what's driving me just nuts inside, is that we shouldn't be doing that at all. Matter of fact, you go ask one of those firefighters, you go ask someone, one of those police officers who wear the very same uniform, who've taken the oath to lay down their life for others. They understand personal sacrifice. They don't want to be placed in a higher stead or in higher value or a higher virtue in their country. They want to be treated right. They want to be treated fairly. But this bill puts them and pits them against the military and puts them at a higher consideration by policy. So, Elliot, I get what you're saying. You've narrowed it down, but I don't believe we should be doing that. My appeal is, please do not do this.
Would the gentleman?
I yield to the gentleman.
Yeah, I thank the gentleman for yielding. I don't think, and I know I know the work that you've done in this Congress, because we've been friends for a long time, particularly with veterans and how deeply you care about them. And I don't think by making this mandatory, we are putting these people, these first responders who are affected, ahead of the military. I believe that the military should also be mandatory. Now, we can argue that we don't have the money for it. We can argue that we don't have the money for a lot of things. But I don't think it's fair, Steve, to say that because we have not made the military mandatory that the 9/11 heroes have to be captive. I think that we ought to elevate both groups, not use keeping down one group as a reason for keeping down the other.
Let me the great challenge we're going to face, and I grant it, I'm retiring, I'm leaving here in 10 months. But if this Congress or future Congresses do not address eligibility reform, the mandatory side of the budget will overtake itself in our lifetime. So if we do nothing, OMB has told us the national debt will approach $22 trillion. At the last several auctions, there wasn't even sufficient bidders on U.S. debt, and the Federal Reserve has come in and taken on U.S. debt. So I'm just saying, Elliot, you may want to say, let's just move it to the mandatory side. Let's create more entitlements. Once you announce your retirement, I'm going to tell you what's going to happen to you. You begin to view things no differently than how your constituencies do, even more. So I am absolutely frightened that this Congress is continuing to create more and more entitlements rather than keeping it more on the discretionary and keeping us on our toes. When it's on the discretionary side of the budget, you keep oversight in mind. And that's my appeal to you. My work over the years has been on the Armed Services Committee. I chaired the Personnel Committee. I've done the health, in charge of the military health delivery system. So I get that discretionary side. And now I've spent all the 18 years on the VA on the discretionary health side. And to say, okay, now we've got some narrow group of individuals of whom we should be treated differently. No, we shouldn't be treating them differently. And I believe we should all come together here today, reauthorize the program, Mr. Elliott, and keep it on the discretionary side, and let's do what's right for these people, not pitting them against others. That's my appeal. That's my appeal. I yield to the gentleman.
Yeah, I thank the gentleman, and I know his feelings are heartfelt, but when the gentleman retires or when I retire, we get pensions. Our pensions are mandatory, are they not? There are a lot of things that we have that are mandatory in the budget. So it's not out of the ordinary to say that something that is so important like these 9/11 heroes.
I reclaim my time. The pensions in the VA are also on the mandatory side. So for comp and pen, those are mandatory sides. We're talking about on the health care piece.
Gentleman's time has expired.
Mr. Chairman?
Yes, I would ask, though, I mean, I know we're kind of getting beyond the amendment now, so try to stick to the amendment. I've heard enough about members retiring. I think enough members have retired. We don't need any more retirements. Gentleman from Texas.
Well, I just clarified. Was the gentleman from New York retiring? Did I understand that?
Oh, now they're going to go into that. All right, let's move on.
Actually, Mr. Chairman,
not unless the voters throw me out.
Mr. Chairman, this obviously is an important issue. We did have a very minimal amount of time between the introduction of your manager's amendment. My office and our staff has worked with you on good faith on this. If you will give me the consideration of continuing to work with us before this goes to full committee, I'll withdraw the amendment at this time, and we'll see if we can't work out something reasonable. Mr. Weiner had some valuable comments, and maybe there's a direction we can go here.
That's fair.
I'll ask unanimous consent to withdraw the amendment at this time.
Without objection, so ordered. Are there additional amendments? Are there any amendments on the Democratic side? If any on the Republican side? Gentleman from Indiana is recognized.
This amendment requires the Secretary of HHS. Oh, I'm sorry.
Do we have the amendment at the desk?
Yes.
I ask the clerk to report the amendment.
To the amendment in the nature of a substitute, H.R. 847, offered by Mr. Boyer. Page
The
11
amendment
after
has
line
been distributed
12.
or is being distributed, and without objection, the amendment will be considered as read, and the gentleman from Indiana is recognized for 5 minutes to explain the amendment.
This amendment requires the Secretary of HHS to establish a system to ensure that only individuals legally present in the United States are eligible to participate in the program. The current program functions as a block grant, whereby NIOSH provides funds to the grantees under the Medical Monitoring and Treatment Program. Under the current program, grantees are asked ask the participant if they are lawfully present, but do not have to verify their legal status. And so what this amendment does is we want to make sure that only individuals of whom are lawfully present in the United States can participate in the program. So this is a pretty non-controversial program. As all of you know, all federal programs, including like Medicare and Medicaid, require an individual to demonstrate their legal status, and that's what we're asking for this program to be done, especially if you want to create an entitlement. I yield back.
I'm going to recognize myself in opposition to the amendment.
Are you kidding?
Excuse me?
Seriously? Wow.
No, I'm not kidding. I feel very strongly in opposition to this amendment, and I will explain why. Look, no one under the current program is asked about their immigration status. And, you know, I would point out that even the Bush administration recognized that 9/11 was a special circumstance. The original Victims' Compensation Fund paid family members of those who were killed or injured regardless of immigration status. In fact, according to its final report, outreach efforts were made to convince undocumented eligible claimants that they were welcome in the program. I don't have any information, but I'm sure there are some people who are undocumented who've been using the clinics for the program. The bottom line is that, in my opinion, and the reason I oppose this amendment, is that if you were working as a first responder and you were called there or volunteered to go there and help out, I don't think we should be asking whether you're legally in the United States. And I feel the same way about people who were present that day, who were victims, who died, whether they were, you know, working at the World Trade Center or they were, you know, living in the area. Everyone was attacked and treated as if they were an American. And I think you almost become an American, if you will, regardless of your immigration status, because of the fact that you were there that day and you were injured because it was an attack on the United States. So personally, I feel that it would be wrong to ask people their immigration status. In addition to that, remember, you're getting very specialized care here that's not available elsewhere. So, you know, you might say, okay, if somebody's undocumented, they can go to an emergency room. But they're not going to get the specialized care that they need at these centers where they're specifically treating those respiratory problems for people who suffered because of the attack. So if I'm legal or not, and I don't get that care, then I'm going to end up, you know, dying or getting seriously ill because I don't get that specialized care, and I am dying or getting seriously ill because of someone who was attacking the United States. So I think it would be very wrong for us to say, you know, that because of your status, you can't get the kind of care that's provided here. Remember, this is very specialized care. You don't get it, you could very easily die or get more seriously ill. And if you go somewhere else, you know, either go back to your country of origin or you go to a regular hospital where they don't have that specialized care, you're going to suffer and you could die. I don't think we should look at it in the way that this amendment is proposing. I think it's a very specific circumstance that really should not rely on the person's immigration status. I would yield back because I know other people want. Oh, does anyone? No, I'm going to yield back my time unless someone else would like it. Mr. Green?
Mr. Chairman, to begin with, I guess I'm shocked, and I'm serious about opposition to this because this is something to help people who responded when New York needed it, and they didn't ask them whether they were undocumented or illegal when they went there to help clean up. And this is very serious. And that's why I think it's a serious amendment that we need to defeat. It's just frustrating, I guess. We've dealt with a little bit of tort reform and limiting attorneys' fees. And now to say that it's not for someone who went there. I don't think there was anyone who showed up there who was undocumented. There may have been. But frankly, if they took it on their own to go to New York as a volunteer, and they became ill, why would we not want to help them? And I yield back. Thank you for yielding to me.
And anyone else? Gentleman from Texas, Mr. Gonzalez.
Thank you very much, Mr. Chairman. My understanding is this may be the first of a couple of similar amendments. And I'm going to appeal to the sense of fairness to the individuals on the other side and anyone that may be considering voting for this particular amendment, and especially to the sponsor, because I think we've agreed on certain things in the past, and I know that he has a sense of fairness. Decisions were made some time ago when individuals would have claims or seek treatment from special appropriated funds for those that were there at 9/11 and then helped subsequent to that day. There was no provision, as the chairman has already indicated, that there would be any kind of requirement that would prohibit or restrict care to be provided to those individuals. In the audience, I see individuals that are wearing certain uniforms. Some have T-shirts that indicate who they're with, but they may have worked next to individuals. I really doubt if, as they worked with those individuals to help others and to make the area safer for everyone, that they were really concerned about the legal status of the individual working with them next to them. And I'd venture to guess that today they still have a sense of brotherhood that brought together because of that occasion and the work that they shared. And I'm sure they would also advocate that those individuals also be cared as they develop all of the same diseases. What did these individuals share? It is the same experience, but it was the exposure to the toxic dust. They're going to share the same disease. It is inherently unfair to say they won't share the medical treatment and the monitoring that everyone that was involved in that particular effort did share that day. The 9/11 attacks were definitely an attack on our population, regardless of its composition, but it was much more than that. It was an attack on our principles and our morals and our values and our institutions. That's what that represents. So what are those values? A sense of fairness? Isn't that what always distinguishes Americans? Of justice? And how that manifests itself day in and day out are the laws that we pass in the United States Congress. We believe that the hallmark of the laws we pass reflect those values and those principles. To allow an amendment of this nature to pass denies those particular principles and those values from having any real meaning. This is about fairness and justice, but that's what the laws should be all about. We understand black letter law. What is that law? To all the lawyers here, we know exactly that. But do you remember what was the spirit of the law? And what we pass today will reflect what the spirit of the law should always be: fairness and justice. This amendment will deny those particular important aspects of every law. So I would hope that my colleagues will reconsider their consideration if they're thinking of voting in favor and vote down this amendment.
Would the gentleman yield just the last few minutes? You know, I totally agree with the gentleman, and I understand you're looking at it from the point of view of fairness and all the things you said are true. But just look at it from a public health point of view. In other words, not the person, but the other people in the program. One of the purposes of this program is to do research and to find out whether or not, you know, we're going to have more problems down the road. I mentioned over the weekend there was a report that said that people that were impacted by 9/11 have very serious heart conditions, and they appear to be getting worse. I think it's important to have everybody who was impacted participate in these programs, because it's only by getting and seeing those people and finding out what ailments are inflicting them, that we know what the real problem is and what we're going to face down the road. So even if you don't particularly care about that individual because of their status, for everyone else in the program, it's probably important to see that person and have them participate in the research so that we know what's going on. So I think just from a public health point of view, it would be a huge mistake for us to pass this amendment, because we need to know how people are being impacted to help everyone else. I would yield to the gentleman. Yield back to the gentleman. Gentleman's
I go back, sir. Thank you.
time has expired.
Mr. Chairman,
Anyone on Mr. Barton?
in the sense of fairness, I would point out we've had 3 Democrat speakers in a row.
I apologize. I didn't realize that you had your hand up.
Well,
we'll do 2 Republicans now.
We'll give you the benefit of the doubt that it was an inadvertent
We'll have another Republican after you.
You know, I guess, though, when we're about to have a self-executing rule deeming a bill that we've not seen passed, it's probably okay to ignore the minority. But
that wasn't my intention.
Traditionally, we've at least been bipartisan in recognition, and I
Let me explain what happened, Mr. Barton. Not that it matters that much, but when I recognized Mr. Gonzalez, I thought he was using the rest of my time, and then it ended up that we gave him his own time.
Well, that's the way us Texans are. We just
that's what happened.
Give us 58 seconds, and we take 5 minutes. I mean, anyway, am I recognized?
You are, indeed.
Well, thank you. If you'll put my full 5 minutes up there on the clock, I'd appreciate it.
We'll give you 5.
All right. Okay. I understand the sensitivity of this issue in terms of citizenship verification. I'd like to point out a couple of things. On the minority staff briefing, we are told that under the current program, the program sponsors do ask a citizenship question right now. Now, we can't find that they do anything to verify the answer, but we are informed that at least they do ask the question if the person petitioning to be a part of the program is lawfully in the United States. That is a question that is asked on the program application. That's step number 1. Step number 2, I would point out to my good friend from Texas who just spoke that we're in the process, if this bill moves, of creating a brand new federal entitlement. An entitlement. A federal entitlement. I think it's fair, if we're going to create a federal entitlement, that we have a requirement that the participants and the beneficiaries of that entitlement be United States citizens, or at least in this country lawfully. I don't think that's too much to ask on behalf of the people who are paying for the program, which ultimately are the American taxpayers. Number 3, it's my understanding that the bill before us caps the participants in the program at 15,000. If you do not have a requirement that participants in the program be United States citizens, there is at least the potential, Mr. Chairman, that some U.S. citizens could be frozen out who have legitimate claims by non-citizens who perhaps do not have legitimate claims. And then lastly, Mr. Chairman, you know, when I look at most of the beneficiaries or potential participants in this program, you know, I think it is very unlikely that the Fire Department of New York City and the Police Department of New York City and the various first responder groups of New York and New Jersey, that very many of those routinely hire people that are not citizens or lawful legal residents of this country. So, and then I guess lastly, Mr. Chairman, given the fact that in the health bill markup and in the current bills, and I believe the House and the Senate, there is a citizenship requirement. While I am not quite as surprised as the author, Mr. Boyer, that you and others are opposing it, it does seem to be somewhat at odds with the majority position on other bills in this Congress that have come before this committee. So, you know, I would hope that we could accept this amendment and support it, and then decide how to verify it. So with that, Mr. Chairman, I thank you for your recognition, support the Booyer amendment, and I would yield back.
Gentleman yields back. Is there anyone on the Republican side that seeks recognition? Yes, Mr. Engel.
Glad Mr. Engel has joined the Republicans. Now, if you'll just scoot over here.
Thank you, Mr. Chairman. Thank you, Mr. Barton. Let me state a few things about this. First of all, common decency. All the first responders and workers, regardless of their immigration status, deserve this after being brave enough to do what many people could not or would not do. They rushed to the site of tragedy and violence and worked around the clock to rescue people and comfort people and clean up after a devastating act of terrorism. And they got sick as a result. It isn't only people who are legally here that got sick. People who tried to help, regardless of their status, got sick as a result. No one, including the undocumented workers, rushed to the World Trade Center during and after 9/11 with the selfish expectation of receiving benefits such as health care. They went, no one even thought about it. They went and they worked at the site for the same selfless reasons that their fellow workers did, because people needed help. Now, documented and undocumented immigrants alongside of U.S. citizens worked for months, including inhaling the air which the federal government told them was safe to breathe. In my opening statement, we held up what Christy Todd Whitman had said, that it was fine for everybody to come down there and breathe. The air was great. They listened to what our government said, and our government lied. So many clean surfaces with a bucket and wet rag, as the government specifically recommended. They did it. Now, I want to also point out that under the Bush administration, they recognized that 9/11 was a special case for undocumented immigrants. The original Victims' Compensation Fund, run by Kenneth Feinberg under the Bush administration, and Kenneth Feinberg received accolades for his work on all fronts. This Victims' Compensation Fund compensated family members of those who were killed or injured, regardless of immigration status. So that's a precedent here at 9/11, the World Trade Center. In fact, according to the Feinberg's final report, the fund, under supervision by then Attorney General Ashcroft, undertook intensive outreach efforts to convince undocumented eligible claimants that they were welcome into the program. So if they were welcome into the program, why would we not welcome them now when they're the ones who got hurt? Now, this Congress has recognized that 9/11 was a special case for undocumented immigrants. Last July of 2009, the markup of H.R. 847 in the House Judiciary Committee, that bill reopened the Victims' Compensation Fund. And the House Judiciary Committee then passed a bipartisan manager's amendment by Chairman Conyers and Rep. Lundgren with no limitations on undocumented immigrants. So the Judiciary Committee, whose jurisdiction includes immigration legislation, respected the precedent set by the original VCF under Mr. Feinberg and Attorney General Ashcroft, and the Energy and Commerce Committee should respect it as well. So there's ample precedent here that 9/11, this is a special case, and we ought not to differentiate between who is documented and who is undocumented. I think it's important to set the record clear that precedent has already been set, and it's been bipartisan. I yield back.
Does any other member seek recognition? Gentleman from Kentucky, Mr. Whitfield.
I yield my time to Mr. Booyer.
I thank the gentleman. I have a question for counsel. How does this program apply to individuals of whom may have responded in Pennsylvania when the plane went down, or to those who responded at the Pentagon?
Will the counsel respond to Mr. Booyer, if he's able?
I'm not really able to respond to that, sir. The eligibility criteria in the bill specify, in the case of the responders program, that you be engaged in work at a specific time for a specific set of responsibilities. In the cases of their survivors program, that you live or work in a specific place at a specific time, there's no delineation by state of residence or citizenship. It's where were you at the time? Were you exposed to the plumes? Were you exposed to the hazards?
A responder on 9/11 to the Pentagon, of whom has health concerns, would be eligible in this program?
No, because it wouldn't meet the criteria of this bill.
Because why?
It wouldn't meet the criteria of this bill because it only had to do with the World Trade Center events.
Very good.
Mr. Chair.
The reason I make that point is, Mr. Chairman, we've got members here who are arguing, talking about the national significance. And throw out words of justice and fairness about a national significance. Yet this bill excludes individuals who were responders in Pennsylvania and at the Pentagon. So it is incongruent in their argument. It is a bastardization in their argument. So if we want to talk about New York City and Congress only acting to the benefit of New York City, that's what this bill is about.
Would the gentleman...
This bill is not about the national significance of individuals who responded to a nation that was under attack at the Pentagon. Once again, you're taking individuals who are at the Pentagon, who are the United States military, and saying we're going to treat you differently because New York...
Will the gentleman yield before he goes much further on that? Because I think there's an important point of clarification. Can I just interject here? The people, first of all, there were no survivors on the flight, obviously. And secondly, just the people...
Let me reclaim my time,
because
that's really, Mr. Wiener, rather foolish.
Something
Let me reclaim my time.
Because
this is about...
Wait a minute. Regular order. Excuse me. Mr. Booyer can finish. He has 2.5 minutes, and then I'll recognize...
Responders, Mr. Wiener, we know that.
And then I will recognize
individuals of whom go to a crash site, there's a reason. Crash sites from airplanes are very toxic, not only by fuel, but also human remains. Very, very toxic. So individuals that respond to that site, there's a tremendous health risk at these sites. No differently than at the Pentagon. I just wanted to make clarification for which the council has responded. If you're going to make arguments for the committee and throw your way around...
Regular order. Let Mr. Booyer finish.
Throw the language about the national significance of 9/11, this bill excludes the Pennsylvania incident and the Pentagon. That's what's bothersome here. So you're using this national significance argument to justify why undocumented aliens should be gained access to an entitlement program. If you want to keep this authorize an existing program and use discretionary funds to do so, let's go ahead and do that. The challenge here is when you create an entitlement and use mandatory funding, then you cap it. When you then cap it, then under the cap, there are judgments that must be made. And if you're going to put the undocumented aliens in equal stead with regard to American citizens, you will have a situation whereby someone is not going to be treated fairly. And that's my point. Mr. Wiener, I'll yield to you.
Yeah, and forgive me, I was just trying to interject because I think you're under a misconception about what went on at the Pentagon. The Pentagon recovery and cleanup was supervised by OSHA. Full ventilators. We haven't seen a documented case of a health problem yet because what exactly should have happened at Ground Zero did happen at the Pentagon. Secondly, the Victims' Compensation Fund includes Pennsylvania. It includes the Pentagon. That portion...
All right, let me reclaim my time. You're talking about physical contact with the human. Mental health is also included. So to say that the Pentagon, that anyone who responded was not traumatized by that event, I don't think that would be very fair.
I would be...
I just wanted to say that's included in the eligibility.
Let me just point out, if I could...
Please, wait a minute. Mr. Boyer, are you yielding to Mr. Wiener?
I just wanted to let me take my last 9 seconds. Mr. Wiener, I just wanted to point out mental health is included as a medical eligibility. Please support the amendment. Be fair.
The gentleman's time has expired. Mr. Wiener's recognized.
Chairman, I just want to again, and I appreciate Mr. Boyer's passion for this. I just want to make it clear there are differences between the situation at Ground Zero and the situation at the Pentagon, in that the Pentagon people were protected. But getting back to the substance of the amendment, this represents a change of position by Mr. Boyer. It represents a change of position by the sponsors of the amendment who were here on September 11th. the Victims' Compensation Fund was open to every American who perished that day, every person that perished that day, every person from other countries that perished that day.
Will the gentleman yield to me?
Certainly.
This is the point I just made. If you want to keep this as a discretionary account, I'm with you.
Reclaim my time. It is not. It is a discretionary account. You have the discretionary as a member of Congress to make a 10-year discretionary allocation that is fixed. You keep calling it a mandatory amount only because you seem to be hung up on the idea rather than a 1-year program, it's a 10-year program. There is nothing open-ended about it. The number of people, capped. The number of dollars, capped. The number of years, capped. It is every element of discretionary bill you've ever voted on. But getting back to this notion that somehow the undocumented should be treated differently, that represents a reversal. It represents the Victims' Compensation Fund went to those that were not documented. That's simply a fact, because I know this, because many of them are in this nebulous region now that they're people without a country. They've got hundreds of thousands of dollars from the Victims' Compensation Fund, but they can't open a bank account. And I wanted to show you, this is a picture again from the Daily News, people on the pile pulling out. I'll be glad to send this to you. Spot the one that's undocumented. Bet you can't do it, because no one was asking any questions.
Will the gentleman yield?
Let me just finish making my point if I could.
Sure.
Look, the fact of the matter is this is not some benefit we're giving people. There's no benefit by having 1,000 tons of asbestos breathed into your lungs. There's no benefit by being told by the EPA that the air was safe to breathe when it's not. There's no benefit from standing with your bare hands pulling metal, hoping against hope that one of your friends wasn't pulverized that day. There's no benefit here. No one is asking for a benefit. We're asking to take care of people who are dying, who we've already said as a Congress we want them to be compensated. We did it after September 11th. I have the vote right here that we created a Victims' Compensation Fund, and it voted for, God bless you, by you. Your constituents should be proud of you for that. We're not asking for a benefit. What we're saying is, how are we going to deal with people who showed heroism, who volunteered, who went down to that pile with a paper mask when the chief environmental officer of our country was giving people respirators when they went to the Pentagon, and God bless them for doing that, and said to the people of my city and people who were visiting and people who drove from hundreds of miles to get there, the air is safe. All we're doing is letting them get better health care as they die, Mr. Boyer. That's what we're doing. We don't know where they came from. We don't know why they did it, but thank God they did. It's not a benefit. Stop referring to this as a benefit. And if it is such an important distinction, whether or not this is discretionary or whether or not it is mandatory and whether or not it's entitlement, I will gladly, at any venue you like, say when you want to look at what a discretionary expenditure is, first thing, is it a fixed amount? Check. Second thing, is it a fixed period of time? Check. Third thing, is there a fixed universe of people? Check. I'll have this debate with you. But please, God, the idea that somehow these people benefited when they were working as dishwashers on Windows on the World and they went crashing to their death, that somehow they benefited, or someone who was sitting in a seat on an airline over Shanksville, Pennsylvania, benefited, is just preposterous, I say to my friend.
Gentleman going to yield?
Would the gentleman yield to me instead, Mr. Wiener? The point, look, I can't improve on what Anthony said. What he said is absolutely on point, and I appreciate his comments. But the other thing I want to stress again, there's no other place for these people to go that has the specialty care that's designed for the problems that they faced at the World Trade Center. Where are they going to go? If they go to an emergency room in another hospital, if they go back to the place that they came from, they're not going to get the specialty care that they need. So you're condemning them if they can't go to these special places to go to a doctor or hospital that won't know what the ailment is and won't be able to treat them. So I have to emphasize that as well. I yield back. The gentleman's time has expired. Anybody on the Republican side would like to add to this?
I strike the last word.
Well, you spoke, all right. Let the gentlewoman from
move to
Tennessee.
strike the last word, and I want to yield to the gentleman from Indiana.
I thank the gentlelady. You used the word special. What this bill is doing is saying that we're going to recognize individuals of whom are special at New York City. Why wouldn't you say we're going to recognize the responders at the Pentagon are also
Would the
special?
gentleman yield?
So why does counsel respond to us and say that they are excluded and not part of this bill?
Would the gentleman yield?
Sure.
There's no one who has stepped forward, to my knowledge, who said that, I was at the Pentagon or I was in Pennsylvania when the plane went down, and I need to use these clinics. There's no reason to believe that the ailments and the problems that are being addressed at the specialty care at these clinics that I've emphasized over and over again is care that people are looking for if they happen to be in Pennsylvania or at the Pentagon. I can't emphasize enough, a lot of what we're doing here with these clinics is research, determining these unique circumstances of what happened at the World Trade Center when these planes hit it, and the mixing of the glass and the asbestos and all the other things. We don't even know what the ultimate impact is on these people.
Well,
Every
reclaiming
day.
my time.
It's very special.
Let me reclaim my time for a
Sure.
second, Chairman. That's my point. The reason you want to create this program over a period of time is because individuals of whom may have been responders at the Pentagon, of whom may not be eligible either through the VA or through the military health delivery system, they may have an ailment that may show or manifest itself 3 years from now.
The gentleman will yield. That
you're
hasn't
saying
happened. If
because
they
don't
want to
know today, we're going to exclude them from this bill.
Will the gentleman
So
yield?
let me make a point that you made earlier, Mr. Chairman. We're getting pretty far away from the amendment. The amendment that I've asked here is to ensure that if you're going to create an entitlement with mandatory spending, now we have an issue because we have our programs of Medicaid and Medicare, and they require an individual to demonstrate their legal status. If you want to proceed to authorize this program with discretionary funding, I would withdraw this amendment and let's proceed and move in a bipartisan fashion. But you have chosen, Mr. Chairman, consciously to have this in a partisan manner, not a bipartisan manner. And for that, it's really disturbing to a lot of us over here. I'll yield back.
Will
to
the gentleman yield? Will the
The
gentleman yield?
chairman was yield. Here, Mr. Barton.
Oh,
I don't want to.
The time is Ms. Blackburn's.
Oh,
Ms.
okay.
Blackburn, Ms. Barton.
Oh, Ms.
I
Blackburn.
yield to the gentleman from Texas.
Thank you. I want to point out a couple of things. We're here debating the creation of a new federal entitlement. That's what it is. That may be a 10-year entitlement, but it is an entitlement. We don't have to do that. Those of us on the Republican side, we're not opposed to helping the folks that responded and were impacted by the attack on the Twin Trade Centers or trade towers in New York City. But I think it's a legitimate argument that you don't have to create a new federal entitlement to do that. One of the untold stories so far in this markup is that one of the differences between the plane attack or crash in New York and the Pentagon and in Pennsylvania, because the Pentagon is a federal building, the people that responded to the Pentagon were automatically federal contractors. Since air traffic and air traffic control issues and airline crashes are a federal issue, an interstate commerce issue, the same thing applies there. The people that responded in New York City were not automatically federal contractors, and they didn't have federal indemnity, the people that tried to help. If the city of New York wants to give them indemnity, they can do that. For whatever reason, they've chosen not to. If the state of New York wants to give them indemnity, they could do that. For whatever reason, they've chosen not to. So it doesn't automatically fall back that it is a requirement that the federal government do it. Now, that's a legitimate policy debate. And what Mr. Booyer and his amendment is saying is, at least if you're going to create a federal entitlement, require that the people that participate in the program be citizens or legal residents. Yeah. I mean, I would think that that would be a given instead of having this emotional debate about it. But for whatever reason, the majority has decided to oppose the Booyer amendment. And I think if you took a poll in the country, it'd be 95-5 that non-residents and illegal immigrants shouldn't participate in a new federal entitlement.
Would the gentleman yield?
I'm out of time, but I'll be
Would
happy.
the gentlewoman
The gentleman
yield?
has no time. Mr. Engel, would you like 5 minutes?
I'd like 30 seconds, actually.
30 ask unanimous consent that Mr. Engel be given 30 seconds.
Thank you.
Without objection.
Mr. Chairman. I wanted to ask Mr. Bouyer, the gentleman from Indiana, if he sponsored an amendment to include the people in Pennsylvania and at the Pentagon, and we supported it, would he commit to vote for the bill?
If you make this an authorization with discretionary funding, absolutely.
All right. I think you got your answer. The gentleman yields back his time. Does anyone else want to seek time on this amendment? Otherwise, I'm going to move for a vote. Gentlemen? Okay. If not, there's no further discussion. The question is on the amendment by the gentleman from Indiana to the manager's amendment in the nature of a substitute. All those in favor signify by saying aye. All those opposed say no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to.
Mr. Chairman, we'd like a roll call vote on that, please.
Roll call vote has been requested, and the clerk will call the roll.
Mr. Dingle? Mr. Dingle, no. Mr. Gordon? Ms. Eshue? Ms. Eshue votes no. Mr. Engel? Mr. Engel, no. Mr. Green? I know. Mr. Green? Mr. Green votes no. Ms. DeGette? Ms. DeGette, no. Ms. Capps? Ms. Schakowsky? Ms. Schakowsky, no. Ms. Baldwin? Ms. Baldwin, no. Mr. Ross? Mr. Weiner? Mr. Weiner, no. Mr. Matheson? Ms. Harmon? Ms. Harmon, no. Mr. Gonzalez? Mr. Gonzalez, no. Mr. Barrow? Mr. Barrow, aye. Mrs. Christensen? Mrs. Christensen, no. Ms. Castor? Ms. Castor, no. Mr. Sarbanes? Mr. Sarbanes, no. Mr. Murphy of Connecticut? Mr. Murphy, no. Mr. Murphy, no. Mr. Space? Mr. Space, aye. Ms. Sutton? Ms. Sutton, no. Mr. Braley? Mr. Braley, no. Mr. Waxman? Mr. Deal? Mr. Hall? Mr. Hall, aye. Mr. Whitfield? Mr. Whitfield, aye. Mr. Shimkus? Mr. Shimkus, aye. Mr. Shattuck? Mr. Shattuck, aye. Mr. Blunt? Mr. Blunt, aye. Mr. Bouyer? Mr. Bouyer, aye. Mr. Pitts? Mr. Pitts votes aye. Mr. Rogers? Mr. Rogers, aye. Mrs. Myrick? Mrs. Myrick, aye. Mr. Murphy of Pennsylvania? Mr. Murphy, aye. Mr. Burgess? Mr. Burgess, aye. Ms. Blackburn? Ms. Blackburn, aye. Mr. Gingrey? Mr. Barton? Mr. Barton, aye. Mr. Pallone? Mr. Pallone, no.
Members that haven't voted, the Chairman
Mr. Waxman? Mr. Waxman votes no. Mr. Gordon? Mr. Gordon, no.
Are there any other members?
Mr. Ross. Mr. Ross, aye.
Are there any other members that which wish to be recorded? Gentlewoman from California, Ms. Capps.
Not recorded, Mr. Chairman.
Votes no.
Mrs. Capps votes no.
I think all members present are recorded, so I'll ask the clerk to report the vote.
Mr. Chairman, on that vote, the yeas were 16, the nays were 20.
And so the amendment is defeated. Does anyone else have an amendment? Mr. Barton?
Mr. Chairman, I have an amendment at the desk. It's a substitute for the bill.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 847 offered by Mr. Barton. Strike Title I and insert the following.
The amendment has been
designate
distributed
page.
and without, or is being distributed, and without objection, the amendment will be considered as read, and I would recognize the ranking member for 5 minutes to explain the amendment.
Thank you, Mr. Chairman, and again, in the spirit of trying to work together, we appreciate the bill being marked up at subcommittee to give an opportunity for the minority to suggest some improvements to the bill. Since the bill that's actually before us we only received at 4 o'clock yesterday afternoon, we admittedly haven't had time to fully vet it, but this is at least a starting point. What my substitute amendment does is convert this from an entitlement program to a discretionary spending program. So we are very committed to helping those that need help in New York that did respond or live near the World Trade Centers. We do create and authorize a discretionary grant program. This amendment, if it were to be accepted, would have a monitoring program. It would have a treatment program for first responders and members of the community. We would authorize it at $100 million per year for 5 years. To put that into context, Mr. Chairman, the current World Trade Center monitoring and health program, we are told, operates on a budget of approximately $71 million annually. So we take that $71 million and add $29 million to it. We think that is more than a sufficient increase to take care of the needs of those that would participate in this program. That would be approximately a 40% increase over current spending levels. We have no idea what this program will need to be, 5 years from now. That's why we do have a 5-year authorization. That's not 10 years. It's only 5 years, but it is more than 1 year. It's a 5-year authorization program. That would force the Congress to exercise oversight, and I am absolutely confident that so long as Congressman Elliott Engel is on this committee and this subcommittee, would have good oversight over the program. I also feel comforted by the fact that if the majority currently in the majority stays in the majority, having a subcommittee chairman from New Jersey would probably mean that there would be good oversight over this program. So those of us in the minority recognize that there is a need, Mr. Chairman. We simply want to do it on an annual authorized program for 5 years. We want a spending cap that is based on what is actually being spent today, and we do have an allowance of a 40% increase to make sure that if the $71 million a year is not sufficient, then we give them a cushion so that you could grow the program. We think this is much more of a reasonable approach given a $1.6 trillion annual deficit, given all the other competing needs that everybody on this subcommittee is well aware of. And we believe that this would suffice and serve the legitimate needs of those that need to be helped. It would allow responders and community members to be eligible for services. It would allow for an outreach to educate eligible members. It would allow for data collection coordination. And I do need to point out, given the last vote, Mr. Chairman, that it would require citizenship verification. So that may be a reason those in the majority may choose not to support this substitute. But on the other hand, I think in reality that's a reason to support it. Requires an annual audit of the program and a report to the Congress of that audit. So all in all, I think if the subcommittee feels like we need to legislate, this Republican substitute is preferable to the pending bill. I would ask for an aye vote, Mr. Chairman.
Gentleman has yielded back. I'm going to recognize myself in opposition to the amendment. I know there are a lot of different parts to this, but I just want to talk briefly about the discretionary versus the mandate. I know we've already had a lot of discussion about it, but I feel very strongly that we need to have mandatory spending. I think that several members on our side have pointed out that it's not an open-ended entitlement. In fact, it's a capped entitlement. But the bottom line is that even a capped entitlement does have the guarantee of a certain amount of money over the 10-year life of the bill. And I think that's important for several reasons. First of all, let me point out that in putting this together, we actually used numbers that reflected the number of people who were using the program and who would probably use the program over the life of the legislation. And so that's where those figures came in terms of the amount of mandatory spending that's now capped. The gentleman's amendment has a lot less money that's even authorized. But beyond the authorization is the concern which I expressed before and I continue to be concerned about, which is that that means that if it's discretionary, even at the authorized levels, every year these same people have to come down and seek the funding to make sure that they get it. And I am very concerned that as time goes on, the number of people who are out there are going to diminish. Unfortunately, many of them are dying. Many of them are getting very sick. The organizations that agitate every year for this money are going to be weakened over time because the membership is going to disappear. I hate to say it. I hope it's not true and come up with a cure, but that seems to be the reality. And I think it's wrong for us to expect that, you know, every year this group has to come down and seek this money on a discretionary basis. The other problem, too, is that as you get further and further away from 9/11, you know, memories fade. The ability to say that this is something that needs to be addressed, I think, begins to fade as years go on. I don't like to admit that, but I think it's true. So I think we've come up with a very good compromise here in the underlying bill. We have a capped entitlement. We figured the numbers based on CBO, based on the numbers that we think people use in the program, and a slight increase for the few more that would come into it. The numbers make sense. I think the gentleman's numbers do not. They're significantly less, and there's no guarantee that even at those authorization levels that we'd actually have the money for the program. So
would the gentleman yield on that?
Certainly I would.
And I honestly don't know. This is not a trick question. Is the $71 million that I'm briefed at the staff level on our side, is that not the cost of the program as it currently exists?
The 71, excuse me. One, I had to ask, there's 71 in the current fiscal year. The President's budget has 150, which I guess is a little more than twice. I assume that your 100 is something in between. I don't know how you were.
100 is between 71 and 150, Mr. Chairman. It's a 40% increase. I mean, I knew we'd have an argument over discretionary versus entitlement, but I would think getting the Republicans to go on the record for a 40% increase would be something that would cause some pleasantly surprised on your side.
Well, again, taking back my time, whatever the authorization level is, and I understand that the gentleman is trying to strike a balance there, but I think it is too low. But beyond that, I'm concerned about the discretionary nature of it. I yield to Mr.
I think that the gentleman's amendment is very constructive, and I think it gets us close to a place that I think maybe we can come to an agreement. essentially, Mr. Barton, the former chairman, who's been an assiduous fighter for the jurisdiction of this committee, is saying rather than take control of it ourselves and do a 10-year fixed authorization, say fixed appropriation allocation, say make a 5-year and hope for the best in the appropriation committee. Both of us, you and me and the bill and you, agree it should be a long-term fixed dollar amount over a period of time. We have consensus on that now. The only question is how many years and how much. You've got a number, the bill has a number. But I think we have reached closure on the idea that you do need, that we're basically saying the same thing, a 5-year mandatory and a 10-year mandatory, if you put an amount on it, is essentially discretionary. So then the question becomes, how do we protect this committee? If we really want to allocate the money and spend it, as I'm sure Mr. Barton does, we want to spend it also. Let's do it right. Let's do it here. We're going to send it off to our feckless friends in the Appropriations Committee and let them decide?
Well, gentlemen,
when has that been Mr. Barton's position? No one is more tenacious with you and Mr. Dingland fighting for the jurisdiction of our committee. Suddenly you're like, let's let those guys decide? That doesn't sound like you, Mr. Barton. Where is the Mr. Barton that I knew and loved?
My time has expired. Who seeks recognition?
Joe or Roger?
On the Republican side, gentleman from Michigan, Mr. Rogers.
I would yield my time to Mr. Barton.
Well, it's so enjoyable to have a debate with Mr. Weiner, the one-time candidate for mayor of the great city of New York City, and still one of the excellent congressmen from that city. I want the record to show that he's the one that said our feckless friends on the Appropriations Committee. I'm very happy. I have friends on the Appropriation Committee, and I am absolutely certain that if the majority would accept the Barton substitute, that the powerful New York delegation, a fair number of whom are sitting in the audience as we speak, and I think I may be wrong, but Congressman Serrano is a member of the Appropriations Committee. Is that not correct? And I also believe that he is a subcommittee chairman of one of the subcommittees. Is that also correct? I somehow think that he would be able to use his influence to get whatever the full amount that we authorize appropriate. And I may be wrong, but someone who was a personal friend of Frank Sinatra should be able to use some sort of influence to make that happen. So I agree with my friend from New York City, Mr. Weiner, that we are getting closer. That's the benefit of having markups and using the regular process. We're still going to have this debate, apparently, in this subcommittee, whether it's a discretionary program or an entitlement program. But if we begin to move towards 5 years instead of 10 years, and if we begin to move towards an amount of spending that is based on what is actually being spent with enough growth, potentially given the expected population, there is yet hope that we could get an agreement. And I thank Mr. Rogers for yielding to me.
Yield.
I'll be happy to yield to Mr. Booyer and then to Mr. Shaddy.
It's Mr. Rogers' time.
Oh, that's true.
I would be happy to yield to Mr. Booyer and Mr. Shattuck.
I thank the gentleman. Early on, when this came up, I remember Mr. Serrano having a conversation with former member Jim Walsh. And the last time we found ourselves in a predicament whereby we were trying to define potentially undiagnosed illnesses and their impact upon people, it was the post-Gulf War. And at that time, Joe Kennedy and I came together and we created compensation for undiagnosed illnesses and also opened up access for the VA for individuals of whom had these ailments from the first Gulf War. Now, what we had done is that we created a time period. So, Mr. Weiner, don't write out. I'm talking right to you for a second. We created, I just want you to know this, when we created our eligibility for those who were in the Gulf War who had these undiagnosed ailments, we also created a time period, and we also made it discretionary. And one of the best things about making it discretionary over that time period, every year it kept us on the VA committee interested, very, very interested, not only in that classification of that group and how well they were doing, but then also in the medical research. And I remember the importance of baselining the population. And that's what was hard for us, is we couldn't baseline that population because it was an immediate deployment. So when I chaired the personnel committee, I said we need to make sure that we create these physical assessments and get them on the front end. So now when we go into the second Gulf War, that's what we did. We baselined a population. So with regard to the first responders, when Mr. Walsh was doing this, in the position that Mr. Serrano has, we created this baseline so we could have understanding with regard to first responders. We don't necessarily have that with regard to the civilian population. It's when that claimant comes in, then we say we baseline. So what's challenging here for us, and the reason I'm probably just as emotionally involved in this as you are, Mr. Weiner, is this is a population that we also want to take care of, recognizing there's also in this population individuals who are going to come down with certain ailments that they would have had them anyway. But every ailment that they come down with is going to be blamed in their response. And so baselining this is really, really hard. But there's a reason we decided in the other case to go discretionary, and I think that was the earnest effort that at that time Joe Kennedy and I did. I yield to Mr. Shadegg. Oh, I'm sorry. 4 seconds.
Gentlemen's
for the
time
2
is
seconds.
expired. Would Mr. Shadegg like his own time?
I would, Mr. Chairman.
Yes. Gentleman's recognized.
First of all, I'm going to just preliminarily say that I think it's tragic that on a bill of this significance, on an issue of this importance with people's lives at stake and health problems and companies at stake and just the whole issue of how we handle these kinds of disasters in the future, that we're hung up over the issue of discretionary or mandatory. I quite frankly don't understand the argument for why it has to be mandatory, but I can at least cope with or accept some of the arguments, some degree of certainty. I've listened very carefully to the arguments here in this room, and particularly by Mr. Weiner, about the way the bill is written. And I think there is confusion about how the bill is written. I look at page 86 and page 87 of the bill, and I look specifically at section 3151, page 86. I look at lines 24 and 25, or you could really begin at line 16 through 25, and it appears to me not to be capped at 10 years. Indeed, it specifies a certain amount of funding, as I read it, for the fiscal years 2011 to 2020, and then it says a different figure for fiscal year 2021, and then at lines 24 and 25 it says for each subsequent fiscal year the dollar amount specified in subparagraph B. And what that seems to say to me is that it is not a limited or capped or maxed entitlement that stops at some point in time, but rather that it goes on forever and ever and ever. And I think it would be, right now it looks to me like members on this side of the aisle are going to vote against it because it's entitlement, because it goes on forever. I've listened to you say that you think it's capped at 10 years. That's not how I read it. No. If council can specify, is it not in perpetuity?
Excuse me, before council responds. Would the gentleman yield to me?
Certainly.
All right. As I tried to explain in the beginning, the first 10 years are capped at a certain amount, and then after that, it's capped at the $700,000. So it's to continue. But if I'm wrong, would you explain it? I mean, not $700,000, $700 million. But council can respond.
That's correct, Mr. Chairman. After the first 10 years, there's a $700 million.
So it doesn't stop after 10 years. It goes on in perpetuity.
For inflation. Yes, sir.
It's 700 after the first 10 years. It's annually 700, and it's adjusted for inflation, but it's still a cap at that amount.
It's a cap at that amount for every year, forever.
After the first 10.
Right. So it is not, as Mr. Weiner has been saying, it does not end at 10 years. It does not have it has a cap that kicks in at 10 years, but the funding goes on forever and ever and ever. And I guess
the cap it's still a cap. It's just that it's capped at a certain amount for the first 10 years, and then it's capped at a certain amount for each year after. It's still a cap, and it's still an entitlement. We're not arguing with you.
Well, I don't think I yielded the chairman permanently, but if I did, that's fine. I thought Mr. Weiner and I were having a discussion about whether or not
No, Mr. Weiner, look, Mr. Weiner is explaining it differently than I am. We're talking about the same thing. I'm telling you it's mandatory spending.
I still don't think I yielded to you this time, but let me ask Mr. Weiner. Mr. Weiner, would you be willing to consider a requirement that Congress must revisit this language at some point in the future so that it is just at some point in the future? Maybe it's 10 years from now, maybe it's 20 years from now, so that it is as you have been describing it and not as the chairman has been describing it.
Well, if this begins to act in any way like an entitlement, meaning it exceeds the cap, we're going to have to. The moment it goes $1 of need above the cap written in the law, we are doing something that looks entirely like discretionary spending. It is a fixed amount by year, as Mr. Pallone just pointed out. If we need one additional dollar, it becomes an additional discretionary bill. By the way, it's no different than the amendment being offered right now by Mr. Barton. It's structured the exact same way. The difference is Mr. Barton is outsourcing to the Appropriations Committee to actually spend the money when I choose to do it here in the Powerful Energy and Commerce Committee.
So you yourself agree it's an entitlement. Is that correct?
Mr. Shattuck, would you just yield to me? I'm just trying to explain to you that the difference between the mandatory cap or a cap on mandatory spending and what Mr. Barton's amendment does is that we set a certain amount that's guaranteed over the life of the program, and they don't have to go back every year to the Appropriations Committee and seek that amount. Mr. Barton's amendment has an authorization level, but it doesn't guarantee the funding. So this does guarantee the funding. That's the difference.
Gentlemen, since the gentleman has taken a fair amount of my time, I'd appreciate it if I could get an additional minute.
Without objection, unanimous consent to have Mr. Shattuck have an additional minute.
Thank you. Thank you, Mr. Chairman. The point I was trying to bring out is that as I heard Mr. Weiner explain it over and over again, this was a 10-year program. It is, in fact, now, I think we all agree, not a 10-year program. It's a program that goes on in perpetuity.
That's
correct. What I would like to see is that is there a possibility that we can bridge the gap between the two sides on this issue by finding an agreement where the Congress must statutorily revisit and reauthorize the program at a stated point in time, or it goes out of existence? And that was the topic I raised. I think it was a reasonable attempt to reach an accommodation. I believe it, in fact, followed the arguments made by Mr. Weiner, and I hope at some point we could consider that, because I think to debate the program, about which I think there's very little disagreement, over this one issue of one side saying it must go on in perpetuity and the other side saying no, it shouldn't go on in perpetuity, and to let that be the deciding point is a tragic mistake.
Mr. Shattuck, if I could just explain, and maybe I shouldn't do this, but I just want you to understand, when you say in perpetuity, of course it's only in perpetuity as long as there are people alive that are eligible for the program. It sounds so morbid, but once the people are gone, then that's the end of the program. So it's not, when you say in perpetuity, it's almost like you're talking about a cemetery or something. I mean, it's only for the life of the people as long as they're alive.
Actually, Mr. Chairman, I don't know that that's stated in the bill, but if that were true, then you ought to be readily willing to agree that it goes away in 80 years or some number.
It asks for the life of the people that are eligible, and it's a very limited group. Once those people pass on, unfortunately.
I repeat, then you ought to be willing to agree to set a term of years.
All right, let's vote. Does anyone else? That's a good idea, unless someone else has.
I move to strike the last word.
Well, let me ask this. Is there anybody on the Democratic side who wants to comment at this point? All right, I see the ranking member would like to say something. I recognize Mr. Shimkus.
Thank you, Mr. Chairman. This is always a frustrating debate, and I'm not going to focus on the it is an entitlement by any definition. If we can move it to discretionary and do annual appropriations, we'd be over this. We would have marked up this bill in a half hour and we'd be gone. Entitlement spending is 3/4 of our budget. It is growing exponentially where we will have no discretionary spending, and that's our focus. So, but there's other portions of this amendment that I want to put on the table because I think they're very, very important. And what the ranking member does is address who's administrating this program. And under the on the manager's amendment, it is NIOSH. And under this amendment, the addressing is going to the secretary. Now, and council may be able to answer this. Do you have any record of NIOSH other than this program administering any existing health entitlement program?
Council can respond.
I'm not familiar with the organizational history of NIOSH. I'm sorry, I just not.
And this is a pretty important debate for my colleagues. Why have NIOSH do this, and why not have the Secretary of Health and Human Services deal it through regular health care programs and policies?
If I could respond, I mean, they've been running the program.
All they're doing, Chairman, all they're doing is administering a grant program. They're not actually running it like our entitlement programs are run.
Again, I can say is that, I mean, they've been administering it. We have no reason to believe that that has not gone well. I mean, the program seems to be operating fairly well.
Yeah, and as we move into this new regime, then we'll have NIOSH doing negotiations and setting rates with no experience in doing the negotiation or setting rates with health care providers.
Well, this is the language under Section 3132. It's on page 83. Administrative Arrangement Authority. It says the WTC program administrator shall enter into arrangements with other government agencies, insurance companies, or other third-party administrators to provide for timely and accurate processing of claims. So it can be.
Yeah, and I'll just, it's my time, I'll just follow up with that. This seems to only apply to claims processing. On page 61 of the Manager's Amendment, lines 3 through 7, the WTC program administrator shall establish by regulation a reimbursement rate for certain services. And so our question is, does NIOSH have the experience of setting reimbursement rates? And I would say they don't. That's not their business. That's not their job. So not only are we creating an entitlement program, we're giving a new entitlement program to an organization that has no experience in running an entitlement program. So
again, I mean, we can ask counsel, but my understanding is that we're doing this because they've been doing it and they've been doing a good job, and I don't see any reason to change it. I mean, I understand you're suggesting that it be changed, but there's no reason to believe it there.
I guess our question is, why did we dict in your legislation? I mean, what the ranking member does is he says, let's get it to the secretary. NIOSH is under the secretary. So the secretary, almost every federal program goes through the secretary of the whole. What we've done is we've taken it, instead of giving it to the secretary, we said, let's stick it in your sub-department, is what we've said.
I don't disagree, but I don't see any reason why it shouldn't be that way. I mean, the gentlewoman like to, well, it's your time.
Yeah,
Mr. Shimkus,
I'd have to
yield to Ms. DeGette.
I would be happy, honored.
It's from the specific to the general. NIOSH has the scientific understanding of how to respond to these types of occupational diseases. They've done coal miners, they've done people who have these kinds of diseases. NIH is a broader agency that has responsibility for dealing with generalized issues, and then they deal with the NIH does research on the specific diseases rather than the categories of occupational disease that we're talking about. So under the law, NIOSH can draw on the different federal agencies, the NIH, the CDC, the other agencies, if they need that specific pulmonary information or whatever. But NIOSH is the agency that deals with the occupational diseases in general. That's why it's written in the bill like that, and it makes much more sense, frankly, from a position of how to address these types of diseases, to give the jurisdiction within NIOSH, allowing them to draw on the NIH and the CDC and these other agencies.
Mr. Chairman, if I can ask for unanimous consent for 1 minute, and then I'll be done with this.
Sure.
Thank you. NIOSH is under CDC, and I don't disagree with anything my colleague has said, but I would say what we're developing now is a payment system. We're developing an entitlement program like Medicare, Medicaid for this population, and NIOSH is not a payment organization. They are, as you stated, they have specifics in occupational safety and health. They are not the payers. They're not managing the government-sponsored HMO healthcare delivery system. And that's where, if we're doing that for providing healthcare benefits to these folks, we ought to have it in an area of someone who's experienced in providing the payments. And I'll yield back my time. Thank you, Mr. Chairman.
Does anyone else seek recognition?
I move to strike the last word.
Gentleman from Indiana is recognized.
Thank you. I would like to thank Mr. Barton for offering the amendment, and I agree with Mr. Weiner. I think this is a very good compromise language. If we want to include the responders from the Pentagon, this does it. The substitute does that. So we're putting first responders in equal stead. And I think that a first responder in New York City does not think that they are any better than someone who responded at the Pentagon, nor the Pentagon better than someone who responded. You're all the same. And I will also admit I serve in Congress with a bias. My bias is that I believe that men and women who take an oath and wear a uniform and lay their life on the line, I think it's the highest form of patriotism. And my bias is toward them and always has been. So I recognize my passion for those who wear the uniform. And there's something interesting about those who wear the uniform is that they have a value-based system. And it's the only way they can understand how you can go against human instinct and serve someone else that you don't even know. It's a values-based system. There's something deep inside called an intangible that causes them to act, that causes one to go into a burning building, that causes someone to go down a dark alley and experience fear to protect someone else. And making sure that everyone is treated equally is part of that value. Now, part of also of that value is that if we've got a buddy of ours that is in a tougher position than us, we don't put ourselves ahead of them. We put our buddies ahead of we put our buddies in front of us. And so having a bill like this that creates a mandatory spending account that's going to place someone in higher stead than those serving in the military, I just can't believe in a value-based system that a first responder or anyone wearing the uniform would say, yes, do that. I think most of the ones that I have met have said, no, keep us in equal stead. And I think, Mr. Barton, that's what you're achieving by this amendment. We should not be placing a non-responder resident of New York City or at the Pentagon in a higher footing than men and women who wear the uniform. And this bill does that. So I would think that when I think of human valor, doing that which defies logic even at times, I think the witnessing of the Valor Act of a firefighter or a police officer can be no different than someone who's on patrol right now in Afghanistan. I mean, it's extraordinary. And we shouldn't place one in higher position than the other. So, Mr. Barton, I think you've struck the right balance here. I'm hoping all members will look at this. Let's authorize this discretionary grant program. We can monitor and treat the program for the first responders and the community members, both at the Pentagon and New York City. And Mr. Barton, I think you've been very thoughtful here in your substitute. And I think it's the right middle ground. And with that, I yield back.
Thank you. Any other members seek recognition? Gentlewoman from California, Ms. Eshoo.
Thank you, Mr. Chairman. I'd like to ask the council a question. It's been alleged that the way the underlying bill is designed is that it leaves out other groups, i.e. this is simply for New York, and the minority is saying we want to include Pennsylvania and the Pentagon. Is it a correct understanding of the underlying bill that they are covered by the victims fund, the other two groups?
By the World Trade Center Health Fund or by the Victims' Compensation Fund?
The Victims' Compensation Fund.
I don't know the specifics of Title II.
Does anyone know?
The Title II, if that's what we're speaking of, that's just not our jurisdiction.
That's not before our committee, Ms. Escher, but I think that Anthony said earlier that they were, and I'm just going by him because it's not before our committee.
Well, I mean, if it's an important delineation because this is a huge charge that's been made here, that we're separating out the brave from the braver, from the bravest, they're equal to the military, but this is.
But if the gentleman would, would yield, I mean,
I don't think it. I think. I mean, what I want to do is make sure that, for the record, that what's been charged, that be cleared, because that's not the case. Now, what's been given to me by our colleague, Mr. Nadler.
I thought he was a staffer.
Or the staff. Well, he acted as a staffer, right? A, the World Trade Center site, the Pentagon site, and the Shanksville, Pennsylvania site. This is page 94. The term 9/11 crash site means.
So it would appear
I
that
just want
it
to
is.
say that.
I think it's that Title
page,
II.
This is page 94, lines 12, 13, 14, and 15.
It would appear, and this is what Mr. Weiner was referencing, that they are eligible for the Victims' Compensation Fund. That's what he said. Yeah. But again, it's not before our committee, but I think it's pretty clear that they are.
I just would like to yield the rest of my time to Mr. Engel.
I thank the gentlewoman. I just wanted to point out that we talk about the districts, 435 districts, and we say that 431 of the districts have people in it that are affected. And then we talk about the different states and who's applied. And I just want to call my colleagues' attention to this map here. It's the World Trade Center Health Registry enrollment by state. And the white is 1 to 24 employees. Those are the 5 states that enrollees. I'm sorry, the 5 states that have the less. But you can see everything else is pretty much green, which means that 45 or 43 states more, and you can see Puerto Rico is the same way, are enrolled. So these are not people who only were at the World Trade Center. And these are people that came from all these different states. So I just want to point that out because I think it's important to point out when we are trying to differentiate between Pennsylvania or the Pentagon or the World Trade Center. This is something that affects the entire country. And I yield back.
Would the gentleman yield, or gentlelady?
Ms. Escher has the time.
I'd be glad to.
I'd be real. 2 things. One, the Victim Compensation Fund is to compensate victims. Is not connected to the health care delivery system that we're trying to debate here. The second issue is I think that map is very important for everyone to understand that we all have folks that are impacted, and so we're not, we're not trying to be. We want to be involved in this debate because of the funding issue to get to the discretionary annual appropriations because of the national debt and the deficit. We're not unpatriotic that we ask these questions. And we do have people who are affected, who rallied around the flag and went to these locations also. So I appreciate the spirited debate, and there's emotions on both sides. But as a lot of the New Yorkers know, that I've been talking with quite a few of them on this issue, and I just think there's a way we could have done this expeditiously.
Would gentlelady yield?
Well, I have 5 seconds.
Gentlewoman has, who's asking?
5 seconds.
Sure, go ahead.
I just want to know if Mr. Nadler
Bye.
Providing staff assistance to you means he's now eligible for the Energy and Commerce Majority Staff Compensation Fund.
Okay, we won't get into that. The gentlewoman's time has expired. Does any other member seek recognition? If not, then we'll proceed. The question is on the amendment by the gentleman from Texas, Mr. Barton, to the manager's amendment in the nature of a substitute. All those in favor of the Barton amendment signify by saying aye. Aye. All those opposed say no. No. In the opinion of the chair, the noes have it.
Mr. Chairman, could I have a roll call vote on that?
Certainly. The clerk will call the roll.
Mr. Plone.
Votes no.
Mr. Plone votes no. Mr. Dingle. Mr. Dingle, no. Mr. Gordon. Mr. Gordon, no. Ms. Eshue. Ms. Eshue, no. Mr. Engel. Mr. Engel, no. Mr. Green. Ms. DeGette. Ms. DeGette votes no. Ms. Capps. Mrs. Capps, no. Ms. Schakowsky. Ms. Baldwin. Ms. Baldwin, no. Mr. Ross. Mr. Weiner. Mr. Weiner, no. Mr. Matheson. Mr. Matheson votes no. Ms. Harmon. Ms. Harmon votes no. Mr. Gonzalez. Mr. Gonzalez, no. Mr. Barrow. Mr. Barrow, no. Mrs. Christensen. Mrs. Christensen, no. Ms. Castor. Ms. Castor, no. Mr. Sarbanes. Mr. Murphy of Connecticut. Mr. Murphy, no. Mr. Space. Mr. Space, aye. Ms. Sutton. Ms. Sutton, no. Mr. Braley. Mr. Braley, no. Mr. Waxman. Mr. Deal. Mr. Hall. Mr. Whitfield. Mr. Whitfield, aye. Mr. Shimkus. Mr. Shimkus, aye. Mr. Shattuck. Mr. Blunt. Mr. Boyer. Mr. Boyer, aye. Mr. Pitts. Mr. Pitts, aye. Mr. Rogers. Mr. Rogers, aye. Mrs. Myrick. Mrs. Myrick, aye. Mr. Murphy, Pennsylvania. Mr. Murphy, aye. Mr. Burgess. Ms. Blackburn. Ms. Blackburn, aye. Mr. Gingrey. Mr. Barton. Mr. Barton, aye. Mr. Waxman. Mr. Waxman votes no. Mr. Green. Mr. Green, no.
Mr. Sarbanes.
Mr. Sarbanes. Mr. Sarbanes, no.
Mr. Chairman, we're
Oh,
told...
Mr. Ross. I'm sorry. Mr. Ross votes no.
We're told that Mr. Shattuck is imminent,
We can wait a minute or two for him,
that his presence is imminent.
as long as he doesn't bring any charts.
Shattuck's not here, right? I know.
He's actually in the back room on radio.
Let me mention that while we're waiting for Mr. Shattuck, that we expect only 2 more amendments, so we shouldn't be that much longer.
Not recorded, Mr. Chairman. Mr. Shattuck, aye.
I think that's it. Everyone else who wishes to be recorded, the clerk will report the vote.
Mr. Chairman, on that vote, the yeas were 11, the nays were 22.
Thank you. So the amendment is defeated. Are there any other amendments to the manager's amendment?
Mr. Chairman, I have an amendment.
Mr. Shimkus?
It's Amendment ECMIN 004.
Clerk will report the amendment.
Amendment 2, the amendment in the nature of a substitute to H.R. 847. Mr. Whitfield? Oh, offered by Mr. Shimkus. Page 92, after line 16.
The amendment is being distributed, and without objection, the amendment will be considered as read, and I would recognize Mr. Shimkus for 5 minutes to explain the amendment.
Thank you, Mr. Chairman. This amendment states that the program established in the bill would be sunset effective January 1st, 2014, if health care reform, H.R. 3590, is enacted into law. It also reduces the amount of funds available in the underlying bill by 60% to account for the fact that if this program will then sunset at 2014 and the entire $5.1 billion will not be needed. The majority is seeking to enact major health care reform, as we know this week. If health care reform is passed, then the federal government would have established a program to provide health care to all persons in the United States that would cover any pre-existing conditions. Thus, there will be no further need for the program established in this bill. Why would the federal government need two separate entitlement programs that serve the same purpose? And with that, I yield back my time.
I yield myself time in opposition to the amendment. I appreciate the fact that my ranking member is assuming swift passage of the health care reform bill, and I hope he's right. In fact, I hope it happens in the next few days. But even with that, and I think I've emphasized this quite a bit during the markup today, this bill has very important, or I should say this program with the centers, has very important provisions that monitor and track the illnesses resulting from 9/11 to better understand the medical conditions. It ensures research on how best to treat them now and in the future should an attack like this happen again. I have been many times to the center in my district, which is at UMDNJ on the Rutgers campus in Piscataway. And frankly, when I go there, the thing that most stands out for me is the extent to which we are uncovering illnesses and unique circumstances that we're not necessarily aware of. And so I can't emphasize enough the research, the work about potential future illnesses and the impacts. And I think that so the point I'm trying to make is regardless of whether we do the larger health care reform, it's still very important to have these programs in place. And the larger health care reform will not address that. There are other reasons I could cite, but I think I just like to stick with that because I think that those programs in themselves and the existence of those are enough reason that this should continue even when we pass the larger health care reform. I would yield. Sure.
Thank you. Again, the point is twofold. One is we have the registry. We're going to continue to monitor and track. Part of this debate is health care services delivered. And again, that was part of my last debate, NIOSH versus the Secretary. If we have national health care, we have state exchanges that people will be in because of this new federal mandate that will have basic standards and address pre-existing conditions. The health care component of this debate, I think, is credibly argued that this delivery then should be through this new system we're establishing. So I thank the Chairman for yielding, and I return the time.
I yield back. Does anyone else on the Republican side seek to be recognized on our side? Okay. Then we'll move to a vote. The question is on the amendment by the gentleman from Illinois, Mr. Shimkus, to the manager's amendment in the nature of a substitute. All those in favor of the Shimkus amendment signify by saying aye. Aye. All those opposed say no. No. The opinion of the chair, the noes have it, and the amendment is defeated. Are there any additional? Mr. Burgess, you have an amendment? The clerk will report the amendment.
Could we get the number on that?
Excuse me, you don't have it?
No, I need the number.
The number, Mr. Burgess?
008.
Okay, thank you. Amendment to the amendment in the nature of a substitute to H.R. 847 offered by Mr. Burgess.
The
Page
amendment is being
80,
distributed,
line
and
22.
without objection, the amendment will be considered as read, and I recognize Mr. Burgess for 5 minutes to explain the amendment.
I thank the chairman. This is an amendment that attempts to get at some cost sharing. This amendment increases the cost share of New York City to 50%. Under the bill and the manager's amendment, New York City has a 10% cost share, which is capped at $510 million for the first 10 years of the program. Now, New York currently has a 50% federal medical assistance percentage, or FMAP, for Medicaid. This amendment would require the same match rate for the program created under this bill, largely for the same reasons that the FMAP was created in the first place. That is, recognizing that the city, as the fiduciary instrument, has a role to play, and that incenting cost control will lead to more benefits being available for more people. The New York City, like every other federal health entitlement program, should be required to pay a percentage of the cost of the program. The danger is, if we don't do something more than the 10% with the $500 million cap, the tendency could be to shift health care costs onto the federal government. Now, I'm perfectly prepared for someone to say that a 50%, that 10% is just right, 50% is too high, but let's talk about this, because if we can adjust to ensure a reasonable level that makes sure that the incentives are not there for the city to go up to their cap as quickly as possible and then fit as many people as possible then on the program. There needs to be an element of control in this. We've heard the argument between discretionary and entitlement all afternoon. This is a way to impart some level of cost control to the program. And thank the chairman. I don't see about the time, but I'll either yield to anyone who wants time or I'll yield back to the chair.
Yeah, Mr. Engel, I yield to, strike the last word, 5 minutes from Mr.
Yes.
Engel.
Thank you very much, Mr. Chairman. Let's put this back into context. The September 11th attack was an attack on the United States. It was an attack on New York City, but it was an attack on the United States. And therefore, addressing the injuries caused by the toxins at Ground Zero should be a federal responsibility. We held up a sign before. The federal government has culpability. The federal government said the air was safe when it was not. President Bush asked Wall Street workers to open up the financial district, and the federal government offered tax credits to entice people to move downtown. So dealing with the health effects should not become a burden to New York City. We showed another chart here which showed that the people who were injured, the first responders who were injured, come from virtually every state in the Union. So this is not only a New York City problem. This is a United States problem. The bill is currently drafted already requires New York to put up a 10% matching cost share for the entire program, up to $500 million over 10 years. And New York City has already spent millions of dollars caring for those who are injured by the toxins at Ground Zero. So, you know, while it might play well back home to beat up on New York City, the fact is that New York should not be forced to pay a disproportionate burden. Again, New York was attacked because it's the premier city, but it was attacked because it's part of the United States of America, and the first responders and the people who are injured and the people who will benefit by this come from every single state. And I just think, I cannot think of anything that is more, morally imperative than we help these people who selflessly ran to save other people's lives. It's as simple as that. And we can talk about shifting the burden or playing these games. The fact of the matter is the federal government bears the responsibility, and we should have the responsibility.
Would the gentleman yield?
Yes, I would yield.
I don't know that you have any statistics, but I mean, I just know that the New York City has spent millions of dollars caring for those injured that is in no way probably even accountable at this point. So I think that we wouldn't be able to even figure out how much additional money the city has spent.
Well, if the chairman would yield back to me, the statistics I have to answer his question is that New York has so far spent almost $57 million to pay for that.
All right.
Would the gentleman yield?
Certainly.
I guess the issue from Dr. Burgess and our side is no one, in drafting and moving this bill, no one gave us any calculation of why 10. And one of the big things that I get frustrated with is the FMAP, which is an entitlement program for our poor that some states get a 50-50 match and some states get a 70-30 match, and politicians pick winners over losers. And that's a very personally frustrating thing, being from a 50-50. New York's a 50-50 state. Right. So you understand. So this gives us an opportunity to raise that and ask the question, why 10, and just put on the record that some states have it better than others because of the Medicaid, the percentage match. And I think that's why I appreciate Dr. Burgess at least raising this.
Just reclaiming my time for a minute. And as I said before, when I disagree with the gentleman, I know that he's sincere, and I know he's fighting for his state. But I just contend, and I think we have contended on this side, that the events of 9/11 are so egregious and apart from anything else that's really happened, that we don't think it should be really, battling in the same arena for all these other inequities, which are inequities. But this is a unique case, and the federal government should come forward.
Would the gentleman yield?
I would.
Final few seconds.
I would.
I think Mr. Shimkus raises a good question. Why any? Why should there be any share? I mean, I don't understand. If you only think there should be a share is if you believe that New York City was attacked on September 11th. And I think all of us have heard President Bush, and many of us have said that this was an attack on our country. I don't think that there should be any match. Mr. Burgess was a sponsor of the bill that had 10. You were a sponsor of that. The 10 was in the original bill. I think it is an effort to try to acknowledge that, yeah, there's some responsibility may exist there. I'm not crazy about it. I think the sponsors aren't crazy about it. But I think it raises a much larger philosophical question. Are we solving a problem for the Congress and the federal government here? When we passed the Victims' Compensation Act, we said we were. Today, I guess we're saying only 90% or 60%. I just don't understand where this diverted and became a local problem. Now, we do have 431 congressional districts have people that have currently come forward. Should we apportion the taxes to those people somehow? Should we charge each of those localities? If you're a population of 100 people and one of your people that you pay whatever, I don't believe we should. It is a concession. It's not a small one. New York City has enormous deficits right now. It's a significant one. New York City is still, to this day, her economy is suffering by the fact that we have a largely unbuilt hole in the ground down where at ground zero. There's no doubt about that. There are businesses that left that area that still haven't come back. So there's already a cost that's been exacted from New York far beyond any city I think is maybe in American history has ever withstood. So I think Mr. Shimkus is right. Let's just think about it and why it shouldn't be zero.
Mr. Chairman, if you yield to me for a moment.
I think the time has expired. Who had the time? So,
in the interest of,
you want to ask unanimous consent?
Valid points have been raised. 10% in the bill.
All right, let's ask Mr. Burgess unanimous consent for an additional minute. Gentleman's recognized.
Legitimate points have been raised. 10% is in the manager's amendment. It's been pointed out we've had less than 24 hours to 10% in the bill.
A regular order, please. It's Mr. Burgess's time.
All I would suggest is perhaps as a point that could be open for discussion. We do have some time between the subcommittee markup and marking up in full committee. I want to be supportive of you, Mr. Weiner. I am trying as hard as I can. That was the reason I put my name on the bill, and very few members on this side of the dais did that. I want to work with you, but at the same time, there are some cost constraint realities we have to deal with. All of us who practice medicine, all of us who are providers, live with those every day. And I'm just saying we should have that discussion. Maybe 50% is too high, maybe 10% is too high, but we've never really had the discussion. Between now and the full committee markup, I pray that we will, and I'll move the unanimous consent to withdraw the amendment.
The only thing I appreciate withdrawing it, and we can have discussion, but I just didn't want anybody to think that I was agreeing to increase it beyond the 10%, because I'm not agreeing to that.
Mr. Chairman, I'd like to ask a question also, if I could.
Well, first of all, does the gentleman still want to withdraw the amendment? Or why don't we yield to the gentleman from Kentucky before it's withdrawn? The gentleman has 5 minutes.
Well, I want to thank you, first of all, and I know that we've taken up a lot of time, but this is an important piece of legislation. And as we move toward the full committee, I do think it's imperative that we understand completely what is going on. Under the Section 3151, when they talk about the World Trade Center Health Program, they say that out of the Treasury, out of general funds, there would be $5.1 billion between 2011 and 2020. And then on page 81, they talk about that New York City is not required to contribute. New York City has a responsibility to contribute up to 10% of some cost for some program. So my first question would be, the 10% that they're supposed to contribute is calculated from what cost? And then, in addition to that, it's my understanding that the 10% is capped at $510 million. And then it's also my understanding that New York City has credited to that $510 million any monies that they've paid out to victims or workers' compensation and so forth. And so my question would be, how much does that add up to?
Before you proceed, and we can ask counsel, but the reference you're making to on page 81, I mean, that is 10% of the total amount capped. In other words, it's 510 million, I guess.
So that doesn't have anything to do with the World Trade Center Health.
No, I'm just trying to say that the total is capped for the first 10 years, and then the amount each additional year is capped, and New York City contributes no more than 10% of that. But yes, you're right that money that's been spent on treatment through workman's comp would count for that. But it has to be money that's actually spent on treatment. Would the gentleman, would the
but would you
council,
be able to provide that?
Yeah, would the council answer the question?
So let's take this in order. At the bottom of page 80, on line 22, that is the 10% obligation of New York, of the expenditures under this title, the expenditures in carrying out this title. So all the costs that are contemplated under the World Trade Center Health Program, 10% of that. Now, it's subject to, as you point out, on page 81, line 12, over this 10-year period, 2011 to 2020, a cap of $510 million.
Right.
Okay. Now, there's also an offset against that obligation, and that offset is the amount of payments made out by the city through workers' compensation funds or line of duty payments for the cost of treating services for eligible certified responders or certified survivors, the cost of treating their World Trade Center related health conditions.
Okay. And would you be able to get that figure for us between now and when we have the markup in full committee?
Well, we have asked CBO for a cost estimate. I don't know. I mean, they will do an estimate of the federal expenditures here.
You're asking for the amount. I don't know if we have it. We can try to get it.
Well, I mean, that amount will have to be determined at some point because they were going to get an offset for that amount. But we'll have time to address that as well.
Oh, I see. All right. In other words, I'm told that it's the amount from this point forward. So even if we have the amount that they've already paid,
this
that
point
wouldn't
forward.
that wouldn't count for purposes of the bill.
Okay, so it's this point forward.
Right.
Okay.
Council agrees with that? Okay.
That's correct.
So really, we don't need that. I mean, we can try to get it for you, but
No, if it's this point forward, then I don't need
Well,
it.
you'll have from the Congressional Budget Office, when we get the estimate, you'll have their projection of federal expenditures each year.
Okay.
Okay, and then 10% of that will be New York's obligation here. I'm not sure whether they'll be able to provide the offset associated with the workers' compensation and line of duty payments. I just don't know.
Thank you. Thank you.
okay. Now, do you still want to withdraw your amendment? I'm not saying we can't have discussion, but I just didn't want you to get the impression that I was going to agree to more than 10%.
I think Mr. Whitfield's question points up that this is an important part of the discussion that we should have in the interlude between this markup and the full committee markup. So, yes, I would ask for unanimous consent to withdraw the amendment, and let's continue to have this discussion. I would also ask the chair if it would be appropriate that I ask a question of council.
You have, go ahead. Well, we'll give Mr. Give Mr. Burgess another minute by unanimous consent to ask the council a question before he withdraws. Go ahead.
Is the Congressional Budget Office here at the table today?
No, sir.
Has the Congressional Budget Office provided us a score on this bill?
Not yet.
When would we anticipate getting such a score?
I don't know the answer to that. They have the amendment in the nature of a substitute. They know it's a high priority, and they have other demands.
May I ask, is this a bill that would, in your opinion, be covered under the statutory pay-go rules that we passed
Yes, sir.
a few weeks ago?
Yes, sir.
Have offsets been identified to you that would meet those requirements under statutory pay-go?
Discussions, let me say, it does fall under pay-go. We understand it has to be fully paid for. The authors of the bill have had some discussions with Ways and Means, but nothing's been decided. But we all understand that when it goes there, they're going to have to come up with the pay-for.
Well, just ask the chairman, would it be better to keep those pay-fors within our committee and not turn it over to the feckless members of the Ways and Means Committee?
I didn't use the term feckless. Charlie was here before, but he left, so I guess now we can badmouth Ways and Means too. What was your question again?
Well, should we come up with those pay-fors out of our jurisdiction?
I don't think we should, no. I just want you to know that it will have to be paid for, and that and there have been some discussions, but no, it's not our intention to identify them today.
Mr. Chairman, will we have those pay-fors identified before we go to the full committee markup?
I can't guarantee that.
Should we not under pay-go?
I don't think the pay-go rules require us to do that. That's for Ways and Means.
If our interest is in moving this bill to the floor and securing passage of this bill for the victims, I just think that would be a much more efficient trajectory for.
I understand what you're asking for. The answer is we are not identifying the pay-fors. There have been some discussions, but we're not obliged to do that, and I don't think we should cease. Yeah, before we go to the floor, but he's asking before a full committee, and I can't guarantee you that.
In the interest of efficiency, if we identified those and had those locked down before it went to the floor, we could greatly.
I can't tell you that that's going to happen, and I don't want to represent that. All right, the gentleman has withdrawn his amendment. Are there any other amendments to the manager's amendment, Mr. Shimkus?
Chairman, I have an amendment at the desk. It's ECMIN 001. Oh, 001A.
The clerk will report the amendment.
Amendment.
Clerk will report the amendment. Does the clerk have the amendment?
I do, Mr. Chairman. Amendment in the nature of a substitute to H.R. 847 offered by Mr. Shimkus.
The amendment is being distributed, and without objection, the amendment will be considered as read. And I recognize Mr. Shimkus for 5 minutes.
Thank you, Mr. Chairman. This will be very brief. This is the same amendment that the ranking member offered with one exception, and that's changing the $100 million authorization to the $150 million, which doubles the amount of authorization in the budget this year, and it's also equal to the President's budget address for this program. So this deals with, I mean, we're still focused on this being discretionary, not mandatory. We're more than doubling the amount of the fund in this next year. We are coinciding with what the president, and I don't do this lightheartedly, I am agreeing with the president on $150 million in the authorization, and that's the only change. So with that, I will yield back my time, Mr. Chairman.
And I recognize myself, and I oppose the amendment for the same reasons that I gave before. I don't want to belabor the point. Does anyone else want to address this amendment? Okay. If there being no further discussion, the question is on the amendment by Mr. Shimkus to the manager's amendment in the nature of the substitute. All those in favor of Mr. Shimkus's amendment signify by saying aye. Aye. All those opposed say no. No. Opinion of the chair, the noes have it, and the amendment is not agreed to. Do we have any other amendments?
Mr. Chairman, we haven't disposed of his amendment yet, though, right?
We just did.
You're not asking for a roll call vote? Okay.
He hasn't.
Okay. Then I would like to just ask a couple of questions when it's appropriate.
Recognized, strike the last word.
I don't have an amendment.
Recognized to strike the last word.
On page 47, line 13, when it talks about the WTC program administrator, and it talks about determines that a proposed rule should be promulgated to add a health condition to the list of identified WTC-related health conditions. Normally, I think we would expect that the administrator would request a recommendation from the advisory committee before he would add a health condition that would be covered. Under this language, it's not mandatory. Is that your understanding as well?
That's
Counsel.
That's correct.
Okay. Now, and the reason I'm a little bit concerned, I don't think I'm going to vote for this bill in subcommittee, but if we can make some changes, I think many of us would like to vote for it in full committee. But the reason I'm asking that question, when you look at the list of conditions covered on page 75 and 76, you have such things which are pretty generalized, but like a generalized anxiety disorder is covered. An anxiety disorder not specified is covered. And then you have V codes not related to psychiatric disorders such as marital problems, parenting problems. Those types of things are covered as well. And when we get into things like that, I think it's pretty generalized, and I think it would be very difficult to come up with a causation factor. And so that's something that I would like to explore with some others as we move forward to the full committee. Thank you.
I thank the gentleman. Does anyone else have an amendment? Okay. Then I think we'll move to voting on the manager's amendment in the nature of a substitute. The question occurs on the manager's amendment in the nature of the substitute. All those in favor signify by saying aye. Aye. All those opposed say no. No. In the opinion of the chair, the ayes have it, and the amendment is agreed to. Now we'll go to voting on the bill. I now move that the Subcommittee on Health forward H.R. 847 as amended to the full committee with the recommendation that the bill pass. All those in favor will say aye. All those opposed say no. In the opinion of the chair, the ayes have it, and the bill H.R. 847 as amended. Yes.
I'd ask for a recorded vote.
Mr. Shimkus has requested a recorded vote. The clerk will call the roll.
Mr. Pallone.
Aye.
Mr. Pallone votes aye. Mr. Dingle. Mr. Dingle, aye. Mr. Gordon. Mr. Gordon, aye. Ms. Eshoo. Ms. Eshoo, aye. Mr. Engel. Mr. Engel, aye. Mr. Green. Ms. DeGette. Ms. DeGette, aye. Ms. Capps. Mrs. Capps, aye. Ms. Schakowsky. Ms. Baldwin. Ms. Baldwin, aye. Mr. Ross. Mr. Weiner. Mr. Matheson. Ms. Harmon. Ms. Harmon, aye. Mr. Gonzalez. Mr. Gonzalez, aye. Mr. Barrow. Mrs. Christensen. Mrs. Christensen, aye. Ms. Castor. Ms. Castor, aye. Mr. Sarbanes. Mr. Sarbanes, aye. Mr. Murphy of Connecticut. Mr. Murphy, aye. Mr. Space. Mr. Space, aye. Ms. Sutton. Ms. Sutton votes aye. Mr. Braley. Mr. Braley, aye. Mr. Waxman. Mr. Deal. Mr. Hall. Mr. Whitfield. No. Mr. Whitfield, no. Mr. Shimkus. No. Mr. Shimkus, no. Mr. Shattuck. Mr. Blunt. Mr. Boyer. No. Mr. Boyer, no. Mr. Pitts. No. Mr. Pitts, no. Mr. Rogers. No. Mr. Rogers, no. Mrs. Myrick. Mrs. Myrick, no. Mr. Murphy, Pennsylvania. Mr. Murphy, aye. Mr. Burgess. Mr. Burgess. Mr. Burgess votes aye. Ms. Blackburn. Ms. Blackburn, aye. Mr. Gingrey. Mr. Barton. Ms.
You got time. You got time. You're fine.
Ms. Blackburn? Ms. Blackburn off aye and on no. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Barrow. Mr. Barrow votes aye. Mr. Ross. Mr. Ross votes aye. Mr. Weiner. Mr. Weiner, aye.
Does anyone else seek to be recorded or that we should be waiting for? We'll wait. Mr. Green?
Mr. Green votes aye.
Well, we have I think we're waiting for somebody on the Republican side a couple of minutes.
Barton's coming.
He's coming? Okay, we'll see. Wait for Mr. Barton. That's another issue. Mr. Shattuck?
Not recorded, Mr. Chairman. Mr. Shattuck, aye. Thank you. Right on the board.
All right, the clerk will report the vote. Clerk will report the vote.
Ms.
We don't know if he's coming, so
Okay.
they're just saying to report the vote.
Okay. Mr. Chairman, on that vote,
Oh, here he is. Okay. Mr. Barton? You're not.
not recorded, Mr. Chairman. All right.
Mr. Barton votes no, and the clerk will report the vote.
Mr. Chairman, on that vote, the yeas were 25 and the nays were 8.
So the... Okay. We need to finish this process if everyone would just relax a minute. The motion to forward the bill to the full committee is agreed to, and I would ask unanimous consent that staff be authorized to make technical and conforming corrections to the bill forwarded at today's markup. Without objection, so ordered. Let me just thank, before we conclude, I want to thank all the staff for being so helpful on this. We've spent a considerable amount of time, and I particularly do want to mention my two staff people who spent so much time, and that's Alana and Tiffany, but all the staff and all the members who worked so hard on this. And without objection, the meeting of the Subcommittee on Health is adjourned.